Today, we're diving into a topic that's been a hot debate in India for many years, the Uniform Civil Code, or UCC for short. But before we get started, don't forget to hit that subscribe button and the bell icon so you never miss an update from us. Ready? Let's jump right in.
Imagine if you and your friends have different rules at your homes about bedtime, homework, and TV time. Now, your school proposes a common rule for everyone to follow, regardless of what your parents say. Some of you might like it because it's fair, while others might not because they like their own rules. That's what the Uniform Civil Code is, like a common set of rules for everyone, but it's tricky because people have their own beliefs.
The idea of a uniform civil code dates back to colonial India when the British government submitted its report in 1835 stressing the need for uniformity in the codification of Indian law. The demand for a uniform civil code was first put forth by women activists in the beginning of the 20th century, with the objective of women's rights, equality, and secularism.
When the Indian Constitution was being drafted, there was a lot of debate about whether to include the UCC. Some members like Dr. B.R. Ambedkar, Hansa Mehta, Rajkumari Amritkaur, and Manu Masani supported it, while others like Pakar Sahib Bahadur and K.T. Shah opposed it.
Dr. Ambedkar once said, "I personally do not understand why religion should be given this vast, expansive jurisdiction, so as to cover the whole of life and to prevent the legislature from encroaching upon that field." On the other hand, Pakar Sahib Bahadur argued that personal law is a matter of fundamental right and religion.
Over the years, the courts in India have been the stage for some high-stakes drama, where the personal laws of different religions have been challenged, sparking discussions about the UCC. Let's take a look at some of these landmark cases.
First up is the Shah Banu case in 1985. Shah Banu, a Muslim woman, was divorced by her husband and sought maintenance from him. In a landmark verdict, the Supreme Court ruled in her favor, stating that she should be granted maintenance under a law that applies to everyone, regardless of religion. This decision sparked a nationwide debate about the need for a UCC.
Next, we have the Sarla Mudgal case in 1995. In this case, a Hindu man converted to Islam so that he could marry again without divorcing his first wife. The Supreme Court ruled that a Hindu marriage is not dissolved if one spouse converts to Islam, and thus, the second marriage would be considered bigamous under the Hindu Marriage Act. This case added fuel to the fire in the discussions about the UCC.
Then came the John Balamadam case in 2003. John Balamadam, a Christian priest from Kerala, challenged a law that he believed discriminated against Christians. The Supreme Court struck down the discriminatory provision and once again highlighted the need for a UCC.
Lastly, we have the Githa Hariharan case in 1999. This case challenged a law which considered the father as the natural guardian of a child. The Supreme Court ruled in favor of the mother, Githa Hariharan, stating that the mother can also be the natural guardian. This case highlighted the gender bias in personal laws and added to the discussions about the UCC.
Each of these cases, filled with courtroom drama and intense debates, have highlighted issues with personal laws and fueled the debate about whether India should adopt a uniform civil code.
The arguments for and against the UCC are complex. Supporters believe it can bring equality, protect women's rights, and promote national integration. Critics, however, worry about the loss of cultural diversity, infringement of religious freedom, and imposition of majority views.